To this Prep4Practice, and thank you all for attending in person here in the large pension room in Gray's Inn and remotely in what we hope will be an exciting, instructive and thought-provoking session. We have three eminent speakers who I actually call my rock stars. Okay, they're speaking for 20 minutes each. Professor Richard Susskind, Patricia Shaw and Jacob Turner, and I'll introduce them fully as they each come to speak. They are all leaders in their respective fields. Richard will lead on all things AI, trends, lawyers, the courts, and the future. Trish will speak on AI and data and the changing nature of the legal role. And Jacob will talk about the use of AI in civil and criminal litigation, giving you some case law, including the 2019 Bates and Post Office case, now a film at your local cinema, but I don't think he was in it. There'll be a chance for some Q&As at the end, but please reserve any questions that crop up, please, if you would. Time is tight. There may be some audience participation. I think I'm nodding there at Trish. We want to take away these points, please. 1, curiosity. Learn to question. Ask why, where, how, when. Knowledge. Seek it out and absorb it. Consider the cases in the law referred to tonight. Vigilance, keep a pace of all change. Strategy, use tonight's session to develop your career path or paths because there may be more than one. And flexibility, think outside the box, both in your learning and in your career path or paths. And this will help you to increase your awareness of a barrister's obligations relating to your professional and lay client care, and help you identify sources of advice and best practice for managing your own practice in whatever sphere. To that end, you have a suggested reading research list circulated, and that comprises matters that you'll hear about tonight, as well as a few more for you to take forward if you so choose. There are 5 foundation stones at present for this topic tonight. The European Convention on Human Rights, 1950, the ECHR, the General Data Protection Regulation, 2018, the GDPR, the UK's Human Rights Act, 1998, the UK's Data Protection Act, 2018, and the EU AI Act, 2024. And these are 5 important foundation stones for what has already emerged and what will emerge. So introducing myself very briefly, I'm Karen Ray. I'm still a practicing barrister, not yet retired, 45 years call, which is extremely painful to say, I can tell you now, and a member of Gray's Inn. I'm also a qualified non-practicing nurse. I trained at St Thomas's Hospital in London in the early 70s. I specialise now in regulatory and professional disciplinary law at the bar, and I am now a retired tribunal and civil deputy district judge, having sat for 20 years. I have a great interest in the ethical and responsible use of generative AI and how technology is used in legal practice and in the litigation process. Along with the other things, I sit on the Master of the Rolls Civil Justice Council's Futures Group. So this is a romp through AI. The pace of the implementation of artificial intelligence, AI, globally in the last year alone has been seismic, proliferating at a speed that has surprised and for some even shocked the most expert of those involved. It is a tectonic change to our society as we know it, and it could be truly called a revolution. But as with all revolutions, you have to be alert to the invasive and pervasive forces that can be at work out there. So we've had the agricultural revolution in the Middle Ages, we've had the industrial revolution in the 19th and 20th century, we had the internet and digital revolution starting from the 80s. And now from the 2020s onward, we've got the generative AI, cyber, nano-robotic revolution, what's loosely being called the 4th industrial revolution, involving, for example, the Internet of Things, IoTs, devices that are connected to the internet, AI and generative AI, including agenic AI, where machine learning, where AI works independently to mimic human decision-making. AI has already pervaded almost all aspects of our daily lives, from ordering groceries in the retail sector, all the way through self-drive and autonomous cars, all the way right through to diagnoses in the healthcare sector. For us lawyers, we learn that generative AI has already started to be used in court hearings, in general research, advices, pleadings, and even used by some judges in judgments. Some of it we've read has had some quite horrendous effect. Richard will no doubt expand on this, but some examples of generative AI are as follows. ChatGPT in its various iterations, part of OpenAI, owned by Sam Altman and financially backed by Microsoft. It also operates Microsoft 365, aka Copilot. And OpenAI is valued at $300 billion. Next, Gemini AI, which is owned by Google. Thirdly, Claude AI, which is owned by Anthropic and backed by Amazon. Anthropic's founders started back in the day at OpenAI, and its value was assessed yesterday as $61.5 billion. Next, we have DeepSeek, some of you may have heard of, Chinese, owned by Liang Wenfeng, a hedge fund high flyer from China. It's already been banned in Italy, by Italy, in January, and in February, there have been dire warnings from Luxembourg about it. And then finally, Stable Diffusion, Stability AI's text-to-image generative AI model. The latest Getty Images case has highlighted this company. So AI in that world is awash with money and, I would suggest, venture capitalists. Case law on the topic of AI use in our lives has already broken out. We have AI copyright infringement cases, for example. They're increasing, mostly in the USA, where currently there are 38 copyright lawsuits, and it's worldwide, it's increasing everywhere. The courts have tried to stem the tide of AI advancement impinging on our human rights as best it can, but it sometimes, I think, feels like sticking a finger in a dam. Our speakers no doubt will be touching on this. Jacob, for example, has actually represented Dr. Thaler in the important Thaler patent case. Case law, be that through dispute resolution, happily now in the UK slowly becoming the norm, Richard may well touch on that, or litigation in court. And on the other hand, hard law or soft law. Hard law is sanction-driven statute regulation versus soft law, which is regulation maybe that's softer, self-audit, self-regulation, guidelines, protocols, and so forth. The debate goes on as to which is going to be best to regulate properly AI. All of these deal with these following areas of law: copyright, patent, intellectual property, IP, libel, tort, breach of contract, to name but a few. And these legalistic and governmental existing or yet to be implemented guardrails and protections you may think are vital for the preservation of human rights and freedoms, the right to free speech and expression in whatever form, and the right as human beings to determine our own lives. Patent law, for example, protects our inventions in all areas. This has huge ramifications for the freedom of invention, for the freedom of imagination, and the necessary protection against copying and stealing and implementing the ideas of others in all our areas of life. That would be art, music, literature, machine invention, the lot. The huge dangers of breaches of right to a private and family life, as preserved under Article 8 of the ECHR and the UK's Human Rights Act, which is inextricably linked to breaches of data. And this is an incredibly important area of human rights, and Trish will be no doubt touching upon this. Biased information, skewed, spun, distorted, or plain just misinformation, deep fake, so-called hallucinating AI, where AI makes up stuff that's not true. All these have already contributed to profound injustice and unfairness globally, and have already invoked litigation. It started back in 2020 even, well, it didn't start, but it was as early as then, with Denmark's Syri case, worth looking up. Harnessing the meteoric changes in AI use, including the use of large language models called LLM, and you thought LLM was a law degree, didn't you? Is a daily, even hourly requirement or necessity, such is the speed of change as we speak, even now, this evening here. AI change is happening in the blink of an eye. So the very recent developments on the world stage have, I think, highlighted the tension between, on the one side, the freedom to innovate, which is really important, aligned with the ability to encourage new ideas and innovations and methods, but often, sadly, associated with great riches, as we've heard. The need to balance that against protecting the human species, especially our data, because the data has been described as the oxygen of AI. It's a brilliant description. So do we sacrifice our rights as humans on the high altar of commerce? So proportionality, reasonableness and ethics at all times, but above all, please keep humans in the loop. You've got your reading research list. It's quite important you do have a look at that, because it's an unfolding piece of paper, and you can add to that. Please do so, and I suggest you must. Many criticisms of what's gone on already, but that's the nature of the beast. We are here looking at AI, and we're looking at the reaction of a human being. And some humans are glass half empty, some glass half full. And on that point, if I may quote the master of the rolls, Sir Geoffrey Voss, at the UK Law Tech's 2025 conference, when he said this: "I think it's imperative to build bridges in the legal community between AI skeptics and AI enthusiasts. There's no real choice about whether lawyers and judges embrace AI. They will have to. And there is a very good reason why they should do so." And he suggested that it will be done slowly because we're lawyers. He gave 3 reasons. 1, enabling us to serve our clients. 2, if we're not adept at understanding the capabilities and weaknesses of generative AI, then we won't be able to advise our clients properly about the issues that undoubtedly arise from its application. And he spoke then of negligent or inappropriate use of AI, the English common law helping with liability, and vicarious liability as well. So really interesting. And 3rd reason is that it will save time and money and allow advice to be given and disputes to be resolved far more quickly and efficiently. At that same conference, one barrister attendee said that she had saved, on average, 5 hours a week by using generative AI, and that was the equivalent to a full day sitting for a judge. Food for thought, indeed. Moving on to our first speaker this evening, is Professor Richard Susskind, CBE, Honorary King's Counsel and an Honorary Bencher of this Inn, Gray's Inn. He's been a leading figure on the use of technology in legal practice, projecting into the future since the mid-80s, when he obtained his PhD on law, AI and the law from Oxford University. He's been at the forefront of this topic from almost the very beginning. In 2024, Richard was appointed as Special Envoy for Justice and AI to the Secretary General of the Commonwealth. He has been President of the Society for Computers and Law, the SCL, since 2011. He was Technology Advisor to the Lord Chief Justice of England and Wales from 1998 to 2023. He's written 11 books and is the world's most cited author on the future of legal services. Titles include The Future of Law, Tomorrow's Lawyers, The Future of the Professions, and coming out on the 20th of March, How to Think About AI, a Guide for the Perplexed. I love that title because I'm permanently perplexed. I've worked with Richard on the CJC's Futures Group, of which he was chair from 22 to 24, and I was totally blown away by his knowledge, his warmth, his insight, and his predictions. He is a wonderfully engaging and relaxed speaker, so please prepare to be bowled over. Over to you, Richard.
Well, thank you very much for that build-up, and thank you, Karen, for being the architect of this evening. Good evening, everyone. I want to do 6 things this evening. I want to suggest the mindset you might usefully have in thinking about your future. Then give you a sense, secondly, of what's happening in the world of technology. That'll lead me to talk a little about AI and what this means for lawyers. I'll go on to say something about AI in courts, penultimately give you a variety of views on what the future holds, where AI is taking us. And finally, and to be explained when I get there, I'll tell you a tale about neurosurgeons. But let me start off with mindset. My favorite story in life is about Black & Decker, who manufacture power tools. And apparently when they recruit new executives, they take them off on a course, sit them down in a room, not a room I suspect as grand as this, but they put up a slide of a gleaming power drill and say to the assembled new executives, this is what we sell, isn't it? And they all agree. They say, of course, that's what we sell. We're Black & Decker. Well, the trainers with some satisfaction point to the power drill and say, that's not actually what our customer wants. And they put up a new slide and say, this is what our customers actually want. And the new slide depicts a hole neatly drilled in a piece of wood. This is what our customers actually want, and it's your job to find ever more creative, imaginative, competitive ways of giving our customers what they want. And the lesson here for lawyers, indeed all professionals, is very clear. We have in mind today a particular way of delivering the solutions, the outcomes that our clients want. But that's the power drill. We have a particular set of techniques based on the training you're enjoying. We have a particular set of techniques that allow us to help clients. But actually what clients want is this hole in the wall. And it's not necessarily the legal methodology with which we're all familiar. It might be the resolution of a dispute. They might want a deal concluded. They might want a divorce, a whole bundle of practical everyday outcomes. So I simply urge you not to think or not to be a power drill mentality where you think that the future is perhaps a quicker, cheaper, better power drill. Always focus on the hole in the wall. And the second point I want to make by way of mindset is about technology itself. And I draw a distinction between automation and innovation. Automation is what most people think of when they think of technology. You take some kind of task, activity, or process, you computerize it, you systematize it, you streamline it, you optimize it, but you don't fundamentally change it. And the first 65 years of legal technology has been devoted to automation, to grafting technology onto our existing ways of working. As I've looked across the world at other markets and sectors and looked at really game-changing uses of technology, seldom actually are they examples of automation. More often they're examples of innovation. And by that, I use it very specifically, that term, to mean the use of technology to allow us to do things that previously were not possible. That for me is the great excitement of technology, not simply computerizing what we already do, and do rather well. It's the idea that this immense new development, these existing and emerging technologies might, in the broadest of terms, help us offer access to justice in entirely new ways. So think of the hole in the wall and think of innovation as well as automation. Let me say something about technology. The first thing to say about technology is that our systems are becoming increasingly capable. Forget all the technical stuff for a while, just bear this in mind. Hardly a day passes where we don't hear news of some new technology or app or system or breakthrough or startup. And importantly, we're hearing news of technologies that are taking on tasks that historically we thought could only be undertaken by human beings. My friend in Chicago, Dan Katz, did some fascinating research across a series of years into AI systems, and he gave them the multi-state bar exams to sit. And in the early days, the systems did very poorly. When ChatGPT came out, and that was in 30th of November 2022, he gave that system the multi-choice exams to sit. And the system passed 2 out of the 7 multi-choice papers. Very interesting reaction in the legal world. Some people said, oh, this is hopeless, it only passed 2 out of 7. Others said, this is unbelievable that a system can pass any exams at all. What was more unbelievable in my view is that half a version later, GPT-4 passed all 7 papers and passed the written exam as well. Not only that, it passed it to a higher standard than the average pass mark by law students in the United States. I simply use this as an example of the trajectory we're seeing. Our systems are becoming increasingly capable at a remarkable accelerating rate. And this is underpinned by what is known as an exponential growth in the power of the underpinning technologies. Whether or not you're talking about bandwidth or hard disk capacity or memory or processing power, we're seeing this explosion in the underpinning power of the technology. And this is nowhere more apparent than in the world of neural networks. Again, don't worry about the details, but do note that neural nets are the main technology that underpins modern AI systems. The power of, in the crudest terms, the power of neural networks is doubling about every 6 months just now. And those of you who remember your maths, 2 to the power of 20, that means in a 10-year period, the power of these systems will increase 1 millionfold. And that's a conservative estimate. So we can be amazed, and we should be amazed by the current systems. our minds should be collectively blown by the notion that the underpinning technologies within a decade will be 1 million-fold more powerful. There's no apparent finishing line in this. This is a remarkable phenomenon. No one in China or South Korea or Silicon Valley is or hanging their hats up or dusting their hands off and saying, job done. That's technology, that's AI, let's move on to something else. Quite the reverse. The scale of investment, the scale of talented individuals being devoted, the market appetite for this means there's no apparent finishing line. And this leads me to a fourth point, which I find disturbing in a way, and I call this the not yet invented technologies. In the early days of AI, we can date AI to about 1950, but in the early days, breakthroughs came about every 5 to 10 years. They're currently coming about every 6 to 12 months. And it follows, in my view, that most of the most remarkable developments have yet to be invented. I believe our lives will have been transformed by 2030 by technologies that have not yet been invented. I can't prove that, but that's the trajectory. And the fifth point I want to make about technology is that we already don't understand how these systems work. I don't mean we don't understand how we design them, how we take oceans of data, how we use this clever software called algorithms. And we've got remarkable processing power to train and deploy these systems. I don't mean we don't understand that. I mean for any particular interaction with the systems, there isn't a clear explanation that can be given of how it did what it did. And I was struck when I read Stephen Wolfram's book. Stephen Wolfram, one of the great computer scientists of our generation, who wrote a book very quickly on what ChatGPT is and how it does what it does, how often he says, and we just don't understand why it does this. And we have no systematic theoretical understanding of why it does this. At one point, he even calls it voodoo. That's one of the world's leading computer scientists, not understanding how these systems operate. So there we are. The technologies are, the systems are becoming increasingly capable. The underpinning technologies are growing at an exponential rate. There is no finishing line. The most powerful technologies, in my view, have not yet been invented. And already we don't quite understand how these systems work. So it's not an entirely relaxing profile, but this is the world in which you live. We live at a time of greater and more rapid technological advance than humanity's ever witnessed. And what I simply cannot fathom is why lawyers don't grasp this. I speak to large groups of senior lawyers and ask how many of you have used any of the recent AI systems, and a small number of hands go up. We as a profession have to master this technology. It's laden with legal implications, as we'll hear, and it's laden with legal applications, which is my preoccupation. But to give you another sense of just how rapidly it's moving on, consider the area of brain-computer interface. This is the idea of being able to communicate directly, human beings with machines. There was an experiment with 29 patients suffering from epilepsy, and they had, for the purpose of monitoring their disorder, electrodes attached to the surface of their brain, many thousands collectively. They decided to try an experiment. They played these 29 patients the same piece of music. An AI system then essentially captured the data that reflected the brain activity while these individuals were listening to that music. And that AI system was able to predict and reproduce the piece of music, which happened to be Another Brick in the Wall by Pink Floyd. And you can hear it online, and it's spookily but recognizably that piece of music. This is, for me, just the most remarkable breakthrough, this idea that a system can, on the basis of your brain activity, understand the content of your experience. You think you've got privacy problems today, we're moving into an entirely different era. So what does this mean for our lawyers? What is it, AI and law? It dates to about 1958, the field. That's the first recorded paper, or published paper I can see, a man called Dr. Lucien Mell, in a conference held in Teddington here in England on the mechanization of thought processes. He set the hair running about how we might use essentially AI and law, and lots of activity since then. I was involved in the very early stage, what I call the first generation of systems. We called them rule-based expert systems. And what we did to develop an AI system then was we essentially translated the law into a huge decision tree. And one of the projects that I was involved in, the decision tree, it was a system that advised the law of limitation. The decision tree had over 2 million paths through it. That's the scale. And these systems performed at a very high level, but were ridiculously costly to develop. Then came a second generation of system, which we call machine learning systems. In the first generation, the clever thing about the systems were the jewels we mined from humans' heads, because we used experts to help us interpret and develop these flowcharts. The great instinct and then the exploitation of this idea of machine learning, the instinct was that if we gather together oceans of past data, then we don't need to dig the jewels from humans' heads, but surely all the data we have on the web, we have in our systems, reflect and embody so much of our great thinking, our ideas, our literature, our experience, our culture. And if we just had the software that could detect patterns and regularities, we could use this data to great effect. Well, that software we call algorithms. And broadly speaking, there's been two forms of machine learning system. The first are the predictive systems and litigation systems that can look at large documents, bodies of documents, and essentially predict those documents that experts would identify as the most relevant. And also a whole body of thought and systems that it's said can predict the outcome of cases, often more accurately than human lawyers. That's the predictive form of machine learning system. The generative form, and that's the latest form of AI that everyone's rightly jumping up and down about, generative AI systems, as the name suggests, generate text, they generate music, they generate video, they generate images, in fact, even generate computer code. And suddenly in November, we saw systems that were drafting documents, comparing documents, summarizing documents, producing visual representations of documents, answering legal questions, conducting legal research, putting together legal timelines. Errorful, yes, but the idea that these systems were doing it at all was not beyond our contemplation 4 or 5 years ago, but we really weren't expecting it so very quickly. Now, lawyers often say to me, what does this mean for lawyers? What does this mean for judges? What does this mean for courts? And I think it's an interesting question, because when there's a breakthrough in medicine, the question that is asked is not, what does this mean for doctors? The question that's asked is, what does this mean for patients? And this goes back to my hole in the wall and the power drill. We've not got to think that the development of AI in law is all about us. The real question is, what does it mean for our clients? How will the availability of ever more powerful AI systems affect people's ability to understand, to assert, and to enforce their legal entitlements? And what I see over the next 2 or 3 years is remarkable technological developments, but maybe not rapid uptake. Because I think lots is being said by people who are quite new to the field about how AI might impact law. I think almost all the short-term predictions overstate its impact. But far more importantly, I think most of the long-term predictions hugely understate its impact. Do I think that the job of the barrister will be turned in its head over the next 2 or 3 years? I really don't. But as we move into the 2030s, I actually do think we'll see transformed ways of resolving disputes, very new ways for clients to resolve their difficulties, to understand, as I say, enforce their entitlements. And so, to reuse my language of earlier, I think we'll see a few years for much of the rest of this decade where AI is about automation. It's about supporting and enhancing the way that lawyers currently work. Once we get beyond that, we're in the era of what I call the AI-empowered client, where these facilities will change the way in which people, not just in law, but in medicine and education and so many other areas, it will greatly expand the facilities of individuals, of small businesses and large businesses too. What does this mean for court work? Well, I think we will find in AI the answer to the global access to justice problem. And the access to justice problem is grotesque. According to OECD figures, only about 46% of people in our world have realistic access to lawyers and courts. For most people, the notion of courts represents something that's too expensive, too consuming, too combative. And for a younger generation, perhaps even in the room, it's to some extent out of step in an AI digital society. I am confident within a small number of years, but not yet, we will have the tools that will help people to understand what their rights and obligations are, will help them to formulate their arguments, and will help them to resolve disputes, sometimes in traditional courtrooms and sometimes in different fora. Because we're seeing also the emergence of something I've written about, a book called Online Courts and the Future of Justice. We see the emergence of online courts. And by that, I'm not really meaning AI courts. I'm actually meaning this idea, mainly for low value disputes where there's no oral evidence, there's no physical meeting. Evidence and arguments are submitted online. The judge and it is a human judge, will moderate some kind of discussion and will deliver his or her judgment in electronic form as well. Just have a look at what happens in the Civil Resolution Tribunal in British Columbia, both to see it in action and also to get feedback from those who've used it. And so we'll see different mechanisms for the resolution of disputes. In terms of AI, before hearings, we'll be using predictive AI almost as a form of early neutral evaluation. We'll be able to use these systems to predict likely outcomes of these cases. We'll also be able to use AI systems into which, and we're really not there yet, but we will be, in my view, you'll be able to dump a body of documents and the systems will be able to offer some kind of determination in advance, perhaps, of a hearing. But we have to, in my view, get used to the idea that in due course, if we're going to offer a proportionate, affordable dispute resolution service, that might actually involve autonomous AI systems delivering their determinations. Disconcerting and even grotesque as that might sound to many lawyers. I'm not saying this, and I'm emphatically not saying this is an AI system replacing a judge. A judge is a human being who uses his or her faculties, facilities, abilities, his or her judgment, discretion, mercy, and so forth in deliberating and coming to some formulation of some kind of determination. The question for me is, will states provide an alternative form of dispute service, which is a highly capable AI system, given these systems are becoming increasingly capable? And that question really leads to the big question of what does the future hold in terms of these technologies? How advanced are they likely to become? Am I simply missing the point if I'm thinking that systems could come to some kind of determinations of legal disputes? Well, in my new book, I identify 6 hypotheses about where AI might end up. And they're not pub hypotheses, they're hypotheses from experts in the field. And it's notable there's such a divergence of thought. I'll share 3 briefly with you. The first is the hype hypothesis. And that runs something like this. That says, look, it's amazing what these systems can do just now, but actually they do make mistakes quite often. They rely on irredeemably flawed data. We'll never really be able to have responsible AI on the basis of these generative AI systems. The bubble will burst and we'll go back to normal. There'll be a useful tool in the back office, but they're not going to fundamentally change the way we live and labor. That's the hype hypothesis. The second hypothesis is what I call the Gen AI plus hypothesis. So Gen AI is these generative AI systems like ChatGPT. And this hypothesis said, well, look, there's so much investment going into this sector. There's hundreds of billions, literally, the best minds. The market appetite, as I said earlier, is huge. Look at the trajectories. Think of the as yet uninvented systems. We will surely find techniques for overcoming the bias in the data and for eliminating, for all practical purposes, the mistakes these systems make. That's the Gen AI plus hypothesis. The technologies we have today, and they are remarkable, will be reliable in a number of years. And then thirdly, there's the AGI hypothesis. AGI stands for artificial general intelligence. And that is, and here's a big leap, that's this idea that AI systems will be able to perform the tasks at the level of human beings, any cognitive task that a human being can take on. Artificial general intelligence. If you had asked a good or most AI scientists 3 years ago, when will we have AGI? They would have said 20 to 40 years ever, if ever. If you ask them today, they'll say to 5 to 10 years publicly, and most of them say 5 years. My own view is expect Gen AI plus by 2030. I believe we'll have that. And we need, as a society, and certainly as a profession, to plan for AGI by 2035. I'm not necessarily saying we'll have it by then, but there is a sufficiently serious likelihood that we need to think deeply about that. And I'm afraid policymakers, politicians, most people who you might think in the driving seat are not taking on this question. For me, the fundamental question of our era is, what if AGI? It will transform our healthcare. It will provide the answers to all manner of humanity's great challenges. And it brings a mountain range of threats as well. Let me close just very briefly in surgery. I was asked in 2017 to give a talk to 2,000 neurosurgeons, scary audience. And they asked me to talk about really to answer the question, what's the future of neurosurgeons? And I said to them, opening line, I said, patients don't want neurosurgeons. Literally gasped an audience. I said, patients want health. For a particular type of health problem, I said, you're the best answer we have today, and thank goodness for you. I said, but do you not think in 30 years' time or 20, I don't know how many years' time, people will look back and say it's unbelievable how often we used to cut bodies open. Because the future of healthcare, I said that day and they agreed, was not simply better surgery or even robotic surgery, which I thought I was there to talk about, but surely it's preventative medicine and non-invasive therapy. And we have to have that mindset in law. For me, the great excitement of the future is actually the equivalent of preventative medicine, preventative lawyering, putting the fence at the top of the cliff rather than the ambulance at the bottom, using our legal skills to help people avoid pitfalls rather than fix them when they fall into these pits. And also the idea of non-invasive therapy, this idea, can we find ways of, for example, resolving disputes that are quicker, cheaper, less painful than our conventional ways of working? I don't believe AI is simply about automating what we already do. I think it's going to fundamentally transform what we do. I say again, we live at a time of greater technological transformation than humanity has ever witnessed. You're all going to be involved in this change. You're not simply taking the baton from the person ahead and running in the same way as they have always done. Great quotation I always love from Alan Kay, a Silicon Valley guy, who says, the best way to predict the future is to invent it. And that's my message to you, that you're not simply going to be lawyers, you're going to be people who are going to be inventing the systems and processes that replace our old ways of working. Some see this as very challenging, others see this as a marvelous opportunity. I see it as a route to achieving global access to justice. Thank you.
Thank you very much indeed, Richard. I'm very grateful for that. Our next speaker is Patricia, known as Trish Shaw. She is CEO of Beyond Reach Consulting Limited, which advises on responsible AI, including AI data, ethics, policy, law and governance, and on corporate digital responsibility. She's a solicitor by profession and chair of the Society for Computers and Law, the SCL. She's on the boards of the International Technology Law Association, the International Federation of Computer Law Associations, and Women Leading in AI. Trish is an expert advisor to the Council of Europe on generative AI, an independent expert to the EU Commission's General Purpose AI Code of Practice Working Group on the project advising on the advisory board, project advisory board of the Global Partnership on AI, and sits on the UCAS AI Technology Advisory Committee. She's also an expert advisor on the IEEE Certificate for AI Education, and she's been held up as the IEEE Maestro, or Maestress, as I think we'd like to call it, and sits on the IEEE, BSI, and ISO standards working groups. She is a fellow of For-Humanity, working on independent audit of AI systems. I've worked with Trish on a project for For-Humanity, and believe me when I say what she does not know about AI and data and much more is just not worth bothering about. So Trish, our maestro, maestress, the floor is yours.
Thank you very much, Carol. I'm blushing now. Well, so good evening, everyone. And it really is an honour and a privilege to be here, particularly as a solicitor. Thank you for letting me in through the doors and for enabling me to be within these four walls. Now, we've heard a lot, and I will be talking to you. And I think some of the sound bites we've been hearing from Richard have been about power tools, the need for a mindset shift to enable different ways of working. And ultimately, where I want to take you is that I think we play an important and vital gatekeeper role in the sense of ensuring that we have just outcomes, that we have rule of law, and ultimately we protect populations and people. So that's where I'm hoping to take you today. But before I go there, you're all in your early doors career journey, I believe. And many of you, I'm sure, are incredibly AI literate already. So just by show of hands, get those arms working. How many of you have actually heard of ChatGPT, Lambda, BERT, Bard, Claude, any of the above? Or actually named your own character AI. Yeah, so good lot of the room. So bear with me again, you might need to hold your hands up again, but how many have used generative AI like that just for fun? Okay. How many of you use it for work? How many of you are allowed to admit that you use it for work? Or studies, yeah? How many of you actually know how it works underneath the bonnet? Yeah. And how many of you heard about any industry standards or codes of practice other than the one you just heard from Karen that are being developed in order to apply to it? Okay, a few of you, brilliant. So I want to ask you guys to think about, when are we going to stop seeing these tools as just toys? And when are we going to start seeing them as the power tools that they are? And you'll see why, hopefully in the course of my conversation, and hopefully all of us actually, why I say that. Because fundamentally, these are powerful AI applications that can be used in all manner of purposes and application domains, some for real good and some for actually potentially drastic consequences. And the challenge is, where are the gatekeepers? Where are those who are upholding the rule of law? Where are those who are saying, we don't actually have law that fits this box right now, but we are in this liminal space and we need to create it and be active about it? So I want to sort of take you on a journey of the fact that in my own career, I've been a solicitor, now non-practicing for the last 25 years, and I've moved into this trusted advisor space. And what I mean by that is really to allow us the liberty to not just be really very grounded and have rigor and be robust in our knowledge of the law and being able to apply that, but really have a good grasp of what this means in relation to the technology. So how is it that data is being used? How is it, or what is the way that the technology operates? What are the outputs it creates as per that hole in the wall with the Black & Decker power drill? But what are the outcomes that the AI systems are actually producing in the short term, the medium term, and the long term? And this requires for us as trusted advisors to have that real bigger picture thinking. I'm sure, like many of you, I can get into the devil of the detail. I can really see the nuance of reasonable endeavors or, good faith. Sorry, Europeans, we pulled that one in, and really understand some of the nuance of the terminology we use and get into the devil of detail. But having that big picture thinking and really understanding, what is this technology going to be used for? In what environments is it going to be used? Who is this going to be used with, and why? And really not just understanding the law, but applying it. And for me, I've seen this very much as translation work. And I've been working with organisations and some supranational bodies as well, and NGOs, really learning from understanding the technology and speaking at techies through to plain language, plain English usually, and then moving it into legalese, and trying to really be that translator in that role between the different disciplines that are working. We are all having to work in an interdisciplinary way as that trusted advisor, taking on knowledge from other people and other expert domains, but also understanding the boundaries of our own knowledge and expertise and knowing when to reach out for others. And so I think that's part and parcel of this encompassing trusted advisor role. I'm really working with organisations to think about, the risk, not only to that organisation, that entity deploying that AI technology, but also thinking about increasingly the societal implications of these technological rollouts. And as we've seen with all these technologies that have been so transformative in our very own lives, I'm sure over certainly my own 25 years or so plus, we fall into this fallacy that we think we're going to have this technology come and adapt to us. And maybe as AI becomes more ubiquitous and is involved and seamlessly involved with many of our technologies, we may not think it's adapting us. But rather than us being requiring the technology to adapt to us, we are in reality changing and adaptive. We're adaptive human beings. We're complex adaptive systems. It's amazing what a human being can do and how we can do it. And I think this has already been demonstrated that we adapt to the technologies we use and how we use them, as we've seen with smartphones, as we've seen with social media. And we have to then think about, what is this doing for us? It could be making our lives much more connected, but equally, what is it doing to us in terms of our attention spans, our dependencies, our over-reliance potentially on these technologies? And as lawyers, I think we as a profession historically have been very siloed in our thinking. My goodness, having worked in a 50-50 company myself over the time, you know, the contracts lawyers and commercial lawyers, the negotiation, all, but let it not be the M&A people, mergers and acquisitions people ever doing a contractual negotiation, that was far below them. And then if you needed anything on a TUPE clause, you had to go to the employment lawyer, you know, so we were very siloed, even within our legal teams. And I think we really have to get away from that and become much more interdisciplinary in our working, and really working with language in the sense of we are masters of language, you know, and working in a way that actually works with the people who are engineers, who are data scientists, who are computer scientists, who are sociologists, who are ethicists, who are psychologists, neuroscientists, really working in that interdisciplinary way, trying to understand the context of an AI technology in their domain and translate from what it is that they see and their expertise into that, and bring it to the table. So bringing this back to the law, for us, I think this raises really important questions about how we think about our advice and how we go about advising. And so with our legal advice, it's not just about legal analysis alone now. I'll take an AI HR hiring tool as an example. Obviously, I know people very close to me that have discussed hire view and the like. Anyway, to think about HR tools that are being used today, and they solve a problem. Again, you know, you don't just buy a HR hiring tool for the purposes of filtering CVs. What you want ultimately is a talent pool coming to your business that's going to make your business successful and help run and build a better business. And that's where the outcome a business is trying to achieve. But to get there, there's certain things that we as lawyers will ultimately want to think about. So in terms of the law regarding non-discrimination and equality, particularly if you were using that in the public sector domain, you'd be thinking about public sector equality duty. We'd be thinking about relevant legal requirements around direct and indirect discrimination. We might even be thinking about some of the technical mechanisms that might introduce or mitigate or potentially reintroduce algorithmic bias, where there's discrimination that's introduced and produced by the algorithmic system itself. And then we might want to think about, okay, the data that shapes the system's functioning, what is that? What's its provenance? How does it work? How was it selected? What data from that pool of data was used to kind of train potentially the AI system, to test that AI system and validate its performance over time? So this is the level of the detail that we would want to get into, not just from the legal perspective per se, but into the detail and design of the AI system. And where I think this ultimately takes us is that not only are we looking to translate legal requirements into technical requirements that sit within an AI system, and being able to help advise the business to think about what are appropriate and technical organizational measures in the context of your AI system. How can you think about adhering to a data minimization principle under the GDPR? Or what does fairness look like as an outcome for your AI system? We could help as an organization do that, but we can't do that unless we really know and get under the bonnet of how this AI system operates. And some of the more complex things, as we're going to be seeing over time, is as AI becomes more complex, how transparent really is it? How explainable is it? How interpretable is it? And indeed, from a human oversight perspective, can humans really still be in the loop with regard to these AI systems? So coming alongside a business to think about what are their legal ramifications for rolling out an AI system, particularly an AI HR hiring tool. One, does it do the job for them ultimately? But two, how can they get that system to operate in a way that's designed and developed and ultimately deployed so it's adherent to the law in all levels of the law, both at the kind of code level and the data level, but also in its outputs and operations. And so I think, whilst I'm not asking you in the audience or online to suddenly become STEM experts or legal engineers or go and do a data science course, although there are data science courses available for lawyers, I would say, the idea is that you really need to get yourself to be technically literate and really be able to speak the language your clients are speaking when they come to you with these things. And whilst we've mentioned about the changing the ways of working, obviously soft skills are important. And I think lawyers have a really important role to play in being able to facilitate conversation, to, as I've mentioned, translate from technical speak into legalese and back again. But also to really help bring alongside clients who are introducing them to kind of legal experts who understand the regulatory domains and regulatory landscapes from a big picture perspective. Also really understand the regulatory detail from a very detailed under the bonnet perspective. And working together with data scientists and programmers who can then evaluate the technical specifications that we may not be capable to do, but we need to understand and get assurance from them that what they're telling us is true and valid and correct. And then with domain experts who understand the context of use and how this is going to be applied. And also to think about the scenario planning relating to an AI system, because we always want and hope that an AI system will operate within its intended purpose. But actually, we need to be thinking about reasonable, foreseeable misuse as well, particularly under the EU AI Act. There's the concept of AI system operating within its intended purpose and reasonably foreseeable misuse. And so there are soft skills in that we can be literate, but we can also facilitate those multiplicity of conversations. But I think in true different ways of working that we're finding as well is about co-creation, about the ability for us to work alongside a client, not just in product counseling, but really to affect and move from a kind of compliance orientated and risk orientated and least risk to my organization orientated mindset to a co-creation approach, which is actually creating something that's an outcomes-based AI system that is for the benefit, dare I say, of humanity, you know, and really not only being legally compliant, but also thinking ahead from a short, medium, and long-term perspective that this is something that's going to withstand this test of time and be a little bit more future-proof. And, you know, as we've seen, you know, we are seeing that legal regulation can be a little bit slow to catch up, but we shouldn't have to be relying on that. We've got good heads on our shoulder. We should be able to see from the body of case law that we have before us, the body of law that we already practice, how we can adapt these already existent laws into this liminal space of emerging technologies to ensure that the protections for both individuals and for people groups can be there today. And not least some of the frameworks that I'm seeing in my own work on fundamental rights. So if you'd have asked me 25 years ago, would you be a tech lawyer, you know, in a niche IT law firm, and 25 years later work with the Council of Europe and the European Commission and so on and so forth in the area of fundamental rights, I would have probably laughed. You know, that wasn't certainly where I saw my career trajectory. But what I'm seeing is, as we've seen a world that's cried out for AI ethics principles and AI value frameworks and looking for AI governance, what they're looking for and crying out for is certainty and safeguards. And as lawyers, we can offer that. And one framework that can offer that in terms of certainly individual human rights is the European Charter on Fundamental Rights and the European Human Rights Convention and the UN Human Rights Convention as well. So we've got a number of fundamental rights frameworks that are accessible to us and offer a variety of, working in the context of the AI Act as I am at the moment, working as in standards, technical standards domain, creating basically standards that need to be applied by businesses, AI providers, so that they can be compliant when they're rolling out high-risk AI systems. One, this is an honor and privilege to be part of that. But two, actually to say, how do you translate fundamental rights into technical standards that an engineer can understand? Now, that's been probably the challenge of my career, quite frankly, thinking about what does due diligence look like for not just one fundamental right, but working in the Charter of Fundamental Rights of the European Union, I'm looking at 50. So how do you translate that into a technical language that's plain and clear for them to understand, so they can operate that from a grassroots level, so that essentially I'm co-creating and helping them to co-create a product that's already legally compliant, or at least has the thinking of being, has understanding and is thinking ahead to being fundamental rights, human rights compliant before it's even come out the door, because the idea is this will be conformity assessed and ultimately stamped with some marking before it goes to market. So thinking about that, not only from the assessment perspective, but also then from the and the various different fundamental rights. Well, what if they're competing? And what if they're conflicting? How do you operate that? How do you translate that into technical standards? And that's equally been some of the challenge, to talk to people about proportionality analysis. And I've got engineers glazing over at me and thinking, what are you? You're bringing legalese. We don't want your legal language here. Thank you very much. So really it has to be, again, back to that translation role. And then coming back finally to some of the work that I'm doing with the Council of Europe, this is about setting policy, because there is a liminal space. There are 46, 47 member states with 15 observer countries who are involved with the Council of Europe. Yes, they have this AI framework, though they're all setting this intention that they want to have some kind of regulatory certainty within their countries and their jurisdictions. But AI is global, so we need a global conversation. We need it to be collaborative, cooperative, and cohesive with one another. It needs to be interoperable, which is where the standards come in. These are soft law applications that enable them to work across borders. And so that's why I believe that we as lawyers need to be thinking about, yes, the hard law, but where can the soft law also play a role? And this is also where Council of Europe are thinking about, in terms of my work with them, in terms of generative AI and freedom of expression. What is the impact of people? And what is the impact of populations, both at individual level and at scale? And quite frankly, I'm not going to put fear mongering in here. It's quite frightening to think about what generative AI can and can't do. And there are some wonderful benefits of what we've already heard. But the challenge is also about what happens when you have an AI avatar created about you with your voice, with your image, and you have absolutely no control over it. This is a breach of your personhood. Suddenly autonomy is taken out of your hands, let alone your privacy. And so I think we've got to understand that there is these power tools, as we've talked about. They need to be safeguarded. How can we pragmatically help safeguard them using the rule of law, both hard law and soft law, to ensure that we've got international interoperability and certainty for businesses that apply them? So when you've got an AI system that's being rolled out from this Asiatics, for example, and an AI system being rolled out from Silicon Valley, we can have an apples for apples comparison rather than apples for pears comparison, particularly in how it's going to impact on people. So kind of wrapping up now with the time that we have, I've gone over slightly, is again, I ask, when are we going to start seeing these toys more as power tools, the fact that they have real life implications? When these tools make mistakes, they change people's lives and potentially irreversibly. And I would like to also offer the fact that when are we going to step up to the plate as lawyers and really play our role in that, being vital gatekeepers in holding these very powerful technologies and the businesses behind them to account through the pragmatic roles of justice, rule of law, and dare I say also the use of the human rights framework that is already there. Thank you.
Thank you very much indeed, Trish. Our final speaker this evening is Jacob Turner, a barrister practicing at Fountain Court Chambers Temple. He has acted in some of the world's most significant AI-related cases, including as counsel for Dr. Thaler in the important Thaler case I mentioned earlier. He's also acted for the claimants in the case of drivers against Uber and the OLA cabs, the so-called robo-firing case you may have read about. He's author of Robot Rules in 2018, a book he wrote, and joint author of a chapter in the Law of Artificial Intelligence. That was a second edition in 2024. That's actually the definitive textbook on AI and the law. He's a prolific contributor to the debate on AI and law. His latest article in the Law Society Gazette in January 2025 gives a fascinating, innovative insight into the possibility of the use of AI in representative data misuse claims to combat the historic difficulties of amassing important and shared information on those claims to be pursued. Jacob is on the Attorney General's panel of counsel, and he has advised the government on various aspects of AI regulation. He's been described in the Legal 500 directory as the leading barrister in the AI space, and he's listed in Chambers as a global leader in AI. I've long been a fan of Jacob and his awesome work, and it is with great excitement that I ask him to speak to you now. Jacob.
Thank you very much indeed for that very generous introduction, Karen, and good evening, everyone. I'm going to be speaking about the use of AI to generate evidence that can be used in litigation and arbitration. And we've heard from Karen speaking very expertly about disputes involving businesses and governments' use of AI. We've heard from Richard talking about lawyers' use of AI in their own practices, as well as in terms of access to justice, and from Trish talking about the great importance of standards in AI. And what I hope to be able to do is to tie some of these themes together to look at the benefits, but also the potential dangers and mitigations of dangers in the way that we as lawyers can use AI to win cases or to argue against those who are trying to use AI to win cases against us. There are three cases that I'm going to talk about in particular, but overarching these, there's an important area that is fairly little known in English law, and this is the presumption of proper functioning. So there is a common law rule that has been in place since 2000 to the effect that any computer that takes a decision that's used in evidence is just assumed to be working correctly unless there is explicit evidence to the contrary. This change in the law was made in the year 2000, largely because a lot of people were contesting drink driving bans and convictions. They would say, well, maybe the breathalyzer, which by then was electronic, was not working correctly. And it was very difficult for the police to be able to show that the particular breathalyzer that had been used on a particular stopping of a motorist was actually working properly at the time. So this was becoming a real issue for police forces. And from something as seemingly innocuous as that, we had a very significant change in the law, the consequences of which are only just filtering through now. One of the main examples in which this presumption has been criticized, and this is the first case I'll talk about, is the Horizon litigation that Karen mentioned earlier, the post office scandal. And as I'm sure you'll be aware, this involved decisions that were made by the post office accounting software that found discrepancies in the cash balances of postmasters. And when the postmasters said that there must be something wrong with this, the courts would say, well, that's not what the computer says, and you haven't provided enough explicit evidence of the computer going wrong in some way, so therefore we're just going to go with the computer's answer. In other words, computer says yes. And as a result of that, there was this huge miscarriage of justice that is only now being overturned and required legislative intervention in order to do so. One of the important things about the technology used in the post office is it wasn't AI in the sense that we tend to talk about AI today. Richard distinguished between expert systems, which are purely automated. They use logical functioning, if X then Y, if Y then Z, so that with any given input, you always have the same output. There's no discretion on the part of an expert system, on the part of an automated system. And all traditional computer programs in commercial use up until about the year 2010, they all used automated programming. And that is important because all automated programming can ultimately be traced back to the decision of a human programmer. So you can always look back through every decision, even if it is a decision tree with 2 million points or 2 million routes through, as Richard was talking about, those can always be traced back to the decisions of a human programmer. By contrast, if you take machine learning based systems, you cannot do that because machine learning based systems are autonomous. They can come up with outputs that were not programmed into them. They are not deterministic. And it is that autonomous character of AI programs which makes the application of the presumption of proper functioning to them particularly difficult. So whereas we had problems arising in the Horizon scandal with automated programs, just think about the kinds of issues that could arise where we are increasingly using autonomous machine learning based systems to make increasingly important decisions about people today. So that's the first case that I think is relevant in this regard. And it's noteworthy that the government, as you may know, is consulting currently. They announced a consultation in January this year on the repeal of the presumption of proper functioning. And the consultation period is open until April. Anyone in this room is free to write to the government to say what your thoughts are about whether it is a good thing, whether it is a bad thing, and what you might want the law to be going forward in this area. And that, I would suggest, is a recurring theme when it comes to talking about the law and AI. Things are open to change, and we have the opportunity to affect those changes, maybe even to be making those changes. The second case I'm going to talk about is a case in which I was involved. This was a criminal case. I don't normally do criminal law, but because it has an AI element, I became involved in it. This was the case of the Crown and Akroffi Daniels. Mr. Akroffi Daniels, Jeremy, was a county lines drug dealer. He was caught by the police and he admitted that he was a county lines drug dealer. So that involves basically taking drugs from a city and distributing them in different parts of the country. So not a nice business to be involved in. And he was convicted for this. He pleaded guilty. But the question was, how many years should he stay in prison? What category of sentencing should he be in? And there are various factors, as you may be aware, that feed into the category of sentencing when you're convicted of drug dealing. One of the most important of these is the amount of drugs you've actually sold. If you've just sold a small amount of drugs, then you're unlikely to be categorized in the most serious of categories in this regard. So the question was, how many drugs had Mr. Akroffi Daniels sold? Now, the typical way in which the police would build a case is they would look at the evidence, they might interview people to whom the person had sold drugs, they might try and look for surveillance software, other members of the gang, and so on and so forth. That's not what they did in Mr. Akroffi Daniels' case. Instead, what they did was they took an algorithm and they ran that algorithm through his mobile phone. He actually had 2 SIM cards that he used for his drug dealing activities. And they used that algorithm to detect and analyze the nature of the phone calls that he had made. Now, it wasn't a particularly complicated algorithm. This is what I would call an automated system. It wasn't an autonomous system. What they did was they looked at phone calls of a certain duration and to certain numbers, and they said that based upon the volume of those phone calls, each of those phone calls represented a sale of Class A drugs of a particular amount. And based upon that fairly simple calculation, they arrived at the amount of drugs that they said he had sold over the relevant period, several kilograms. And they put him in a higher sentencing category than he would otherwise have been in. Now, that's a pretty serious thing for a young man who's in his 20s. The difference between being in prison for 3 years and being in prison for 6 or 7 years. So a serious difference to someone's life. And the decision was made very largely on the basis of an algorithm. And the sentencing judge took this into account. I was involved in the application for permission to appeal against that judge's sentencing. And we can start to see here how things like the presumption of proper functioning would feed in to the way in which courts might look at it. And that was something which was relevant in this particular case. The Court of Appeal refused permission to appeal, so we lost. And they said this: so long as the sentencing judge was not hidebound by the decision of the algorithm, so long as he wasn't just taking the algorithm and accepting it, then it was fine for him to have used this algorithm. It wasn't something which was subject to challenge. If Mr. Akroffi Daniels had wanted to challenge it, then he should have produced his own evidence in order to show why the algorithm was wrong. Now put yourself into the shoes of someone like Mr. Akroffi Daniels, not someone with a great education, not someone with significant resources. How on earth is he supposed to disprove the police's algorithm? But this is the situation that we are currently in with respect to evidence on the use of algorithms. The third case that I'm going to talk about is another one in which I was involved. And this was a case at very much the other end of the spectrum from that of Mr. Akroffi Daniels. This involved a foreign exchange fixing cartel that was in operation for some 10 or 15 years. This was the biggest banks in the world who are alleged to have colluded together to agree on what the foreign exchange rate should be. Let's say how many dollars you will sell for euros, how many pounds you will sell for yen, in order to benefit themselves collectively. And they were ultimately sued by a group of asset managers and other commercial counterparties who said, over this period of 10 years when you are fixing the exchange rates, we have lost out by being on the wrong end of the trades that were affected by the fixes. And then when it came to proving their case and showing what damages they had incurred, they did something very innovative, something which, as far as I can tell, had never been done before in civil litigation anywhere in the world. They said, we have trained a machine learning algorithm to be able to detect instances of wrongdoing. And the way they said they did that was they took 500 what they called instances of known market manipulation, and then they trained an algorithm which learned by machine learning, so learned from experience, to recognize future or other instances of the same kinds of behavior. Then they ran it against all of the millions, maybe tens of millions of transactions that has happened in the 10-year period that was subject to the litigation. And they said, based on this, the output of that system, this wasn't generative AI, this was classification AI, but nonetheless, it was machine learning, it was autonomous. They said, based on that, that is our evidence. I was instructed by the banks to try to pick holes in that evidence, to try to work out why it shouldn't be trusted. Now, ultimately, this case settled, so we don't know how it would have been decided upon by the courts, and we don't yet have a precedent of machine learning-based evidence being decided upon in this way in the civil courts. But I think there were some very important lessons that came from undertaking that exercise, and those involved getting under the bonnet and querying how it was that the magic essentially was said to have happened. So if you're given a situation like that, where machine learning is used to create evidence, you might want to ask things like this. What was the data that was fed in to the machine learning system? There's a well-known phrase in artificial intelligence, garbage in, garbage out. If your data is not sufficiently representative, then the output of your system is not going to be accurate. The example in this case involved around 7 types of manipulation. And so out of that 500 examples that the claimant said they had, we asked, well, how many of those fitted into each of the 7 categories? Because there were 7 ways in which the manipulation was said to have happened. Were 400 of the examples type A and the other 100 split between the remaining 6? What was the breakdown? Because 500 might look like a large number, but if you divide that by 7, even assuming there was an even distribution, it suddenly becomes a lot smaller number. And the smaller sample size that you have, the less reliable the data is going to be. It's like if there was a survey of people in the UK and as to what their voting intentions are, and the survey came back by saying 100% of people are going to vote for the monster raving loony party, you might say, well, that doesn't sound quite right. How can that be the case? And if it turned out they only asked one person, that might be the reason, because they didn't have a representative sample size. So really interrogating the data was an important aspect of that operation. But there's a further aspect which we just don't know the answer to, and that is how a court would ultimately deal with the opacity of that system. Because as well as autonomy, another crucial feature of machine learning systems is their opacity, the inability of even those who build them to know exactly how they have functioned. And this was a point that Richard touched upon when he spoke about the eminent AI scientists not knowing exactly how the AI was functioning. And this is a real problem for courts, because we've never before had to deal with a type of essentially expert evidence that no expert can necessarily explain. Certainly you would have an expert who could tell you how the system was set up and what kind of testing had been undertaken, but the actual thought process of the system itself, that remains an unknown. So we just don't know exactly how courts would deal with that. The final thing I'm going to talk about is something that Karen mentioned, and that is the potential, I think, for a positive use of AI in litigation. So I don't want to give you the impression that I disagree with the use of AI in litigation. I absolutely don't. I think that AI could well be used if it is used responsibly and adhering to some of the standards that Trish has spoken about in ways which massively increase access to justice, as Richard was saying. And I'm going to give you one example of the way in which I think this could happen. So there was a major problem at the moment in terms of prosecuting or pursuing mass claims for harms that are caused by AI or algorithms. Now, all of us interact with algorithms every day, multiple times a day, whether it's when you use Google Maps, whether it's when you use a search engine, whether you directly engage with an AI system. All of these things are taking decisions about you. And some of those decisions will be important, some of those decisions will not be important. But where there is a harm which arises from the way in which the AI functions, that harm is going to be writ large. It's going to be applied to everyone who is using that system if they meet the relevant criteria. So there are now lots of situations where we're being harmed or our data is being taken in order to train AI. And yet there are very few successful claims in the UK and in the EU which are brought on this basis. And part of the reason for that is because, generally speaking, the quantum is pretty low in the grand scheme of things. It might be valued at £100, £200, £1,000, but ultimately there's not that much point pursuing currently claims for such small amounts. And also it's very difficult to be able to put a figure on those numbers. There is a provision in the CPR which allows for mass opt-out claims. So someone could bring a representative claim, so long as they can show they have the same interest as everyone else who was harmed. But we've seen in recent years that's very difficult to prove. There was a case in the Supreme Court called Lloyd and Google, where someone tried to do this based upon a mass data breach by Google, which found a workaround to the iPhone's privacy software. But the problem was Mr. Lloyd, the representative claimant, couldn't show that he had suffered the same harm as everyone else, so his claim failed. And more recently, just a couple of months ago, a claim in relation to medical data, again against Google, by Mr. Prismal, failed because Mr. Prismal couldn't show that he had the same attitude to the privacy of his personal data as everyone else, or the many millions of other people who were affected. So how does AI help us here? Well, I think there might be an opportunity for claimants in these types of litigation to train their own algorithm based upon, for example, data that can be taken for free from the companies through data subject access requests, and to using a sufficiently large and sufficiently representative and diverse number of training data in terms of the claimants, to be able to create a program, to create an algorithm which is capable of recognizing and quantifying the harms that people have suffered. And then you can scale that. You can run it on 1,000 more people, you can run it on 1 million more people. The cost isn't going to increase. And so I think there is an interesting irony in the potential for the same technology, machine learning, and the same data, our personal data, as is being used by the very largest tech companies to make enormous profits, to be used against them in order to remedy these harms which may otherwise lack a recourse under our existing legal systems. And I think there is tremendous opportunity for AI to be used in mass data claims, but also in all types of claims, in order to significantly reduce the cost and difficulty of litigation that Richard has already spoken powerfully about being a major barrier to parties litigating. So I'd like to conclude with 3 lessons, which I think echo some of the others that we've heard tonight. The first is that, as those of you entering the profession, or indeed already in the profession, it's important to learn about the technology that we're talking about, and not just treat it as something which is foreign or magical or somehow incapable of being understood. You don't, however, need to be an expert in it. And take, for example, expertise in any of the other established fields. If you are an aviation lawyer, you don't need to know exactly how to build a plane, but you do need to know how to question, how to interrogate an expert witness in that field. And it's that level of knowledge, being able to know what questions to ask, how to think critically about the expertise of others. That's the level that I think you need to be trying to attain. The second lesson is to try to avoid automation bias. Try to avoid just assuming that the AI is correct. And that's whether you're using it as part of your own practice for legal research, to review documents, or indeed in litigation, looking at clients' use of AI, of opponents' use of AI. And that critical thinking, questioning the premises, questioning the data, questioning the training process, all of those things are important when, as I'm sure you will come to do, you look at the use of AI in evidence. But it's also important when you look at the law around AI, thinking critically about whether the law is fit for purpose, whether common law assumptions are fit for purpose. And as we've seen with the ongoing consultation, there is a tremendous opportunity to change and shape the law, which is currently not well suited to AI. The third and final lesson is something that I've actually borrowed from one of Richard's earlier books. And it's a lovely quotation from the great American ice hockey player, Wayne Gretzky. He was once asked, how have you been so successful in scoring all of these goals over your long career? And he answered this: most players skate to where the puck is. I skate to where the puck is going to be. And that is a lesson that I would commend to you all. Don't just look at what the state of the world is, the state of the technology is today. Look at where it is going to be 5, 10 years in the future and skate to where it's going to be. Thank you very much.
Well, thank you very much to our three speakers that have, I think, they have so elided one into the other as to make it such an exciting set of informations that we have from all three, as to our heads are no doubt buzzing. So I wonder if we can look at to see if there are any questions that have arisen either online or that anybody here in the room would like to raise. And we have a roving mic, I believe, here, and the lovely Rachel will take it around. We have a hand at the back, and you'll let me know if there's anybody online. Yep.
Thank you. And that was very interesting, and I feel very stupid. But my question is, we've talked about a lot about AI combating the access to justice problem. How far do you feel that the massive private ownership of AI is actually a barrier to using AI to solve the access to justice problem? And if so, how do we combat that? And who should own AI if not private companies?
Yeah, Oliver, that is a great question. Thank you very much. It's more general on access to justice. One of the, I think, the most disconcerting features of the emerging AI landscape is that there is enormous power, capital, control held in a very small number of businesses. What was quite interesting, as was mentioned, and may have followed, that in China, this DeepSeek system, which perhaps suggests, and it's too early really to know, that the building of these systems may not for too much longer be simply the province of a handful of absolutely massive corporations. It might be affordable to all. I think the way things are likely to pan out is that those very large organizations will still have a major competitive advantage. They'll still have the processing power, they'll still have the access to data, they'll take on board the technological developments of others, inject it into their systems and build faster working systems. And so I think we have a very serious issue of what can be called unaccountable power. And I think in very pragmatic terms, that's demonstrated if you look at, say, GPT, ChatGPT, we could all use freely, but the really amazing version, GPT-01 Pro, which is phenomenal, costs $200 a month. And so you can see quite quickly emerging a world in which people who have access to the best AI in turn have access to the best health treatment. They have access to best education, and in turn they have access to the best access to justice. And so it is an issue. And what troubles me is it's an issue that very few legislatures or policymakers are addressing. It's not to take away from lots of the work that's going on in regulation, but it is the case that the really big issues, such as that, and for example, the impact of technology on the labor force, are not really discussions that current politicians and policymakers have. We all know it's working there. My hope, however, my hope is that even the underpowered systems will be a massive advance on what we have today. For what we have today, for most people, is very little. And so, while I think very sophisticated AI systems will no doubt provide a higher level of legal insight and legal service, my guess is, again, by say 2030, even the everyday freely available systems will be offering access to justice effectively in a way that's good enough. One of the big questions we need to ask in so many of our public services is when is good enough, if not perfect? And so I remain concerned about the big issue that you raise, but in relation to law in particular, I'm hoping even the relatively, and I put this in quotes, underpowered systems will still represent a major advance across the world. I wonder where you're going with this. Do you remember Richard? What were you saying to me, Karen? Yes. I mean, that's one of the great unanswered questions. How it's going to unfold. Will it continue to be a relatively small number of mammothly resourced organizations, or will it be a resource for everyone? And the idealistic view I've for long had and written about is that I would love the AI systems to become like a commons, like a Wikipedia, a service that's globally available. But if you look at the motivation for so much AI just now, of course, it's commercial, and I understand this, but as long as you've got profit-seeking organizations in the driving seat, and you've also at the same time got public services, governments, who are preoccupied with saving cash, you actually are going to have, I think, an industry that's very economically focused rather than socially focused.
Yes, thank you. And I hope that answers your question. I mean, essentially, it's quite gloomy, but we don't really know because it might get better. I mean, if history is anything to go by, you know, the history of the motor car, Ford and all of that, Renault, we're not governed by them. So maybe if we can capture it, we might be able to get free for all. Who knows?
I do think there are a couple of strategies that are being used to try and combat the power dynamic that we're seeing. One is, particularly in the UK, we're using the Digital Regulators and Corporation Forum, is bringing the major regulators together, including the Competition and Markets Authority, to look at how can that Digital Markets Unit, the subset of the CMA, help to really understand and get under the bonnet of the power dynamic that these AI systems present, and whether the question then is, you know, by making it open source, by making it some kind of digital commons, as we're seeing in the UN space, the global digital commons that's happening, and trying to democratize access to data or access to the AI systems that are really powerful, very costly to produce. But once they're created, can be customized, tailored, and the products that are offered off the back of them be plentiful, but you've still got the same source base, if you like. So I know they're looking into it. And also, I think we've already heard as well from Jacob and others about IP and the ability to think about, well, what is our, and I believe go through legislature at the moment, you know, what does copyright and intellectual property, what role does that have? Do we get a chance to have intellectual property and hold some legal substance in our own expression? And what does that look like? And could that be a way of potentially, you know, looking at to find out where our personal data is, looking at where our expression has landed, and to then commoditize it in that way? I think that could take us down a slightly darker trajectory about licensing out our own personal data about ourselves. I don't feel like soliciting myself out in that quite way these days. But, you know, just really thinking about What can we do with the tools that we already have in law to hold this power to account? But I do agree that power is a problem. It's a geopolitical problem, as we see nations being exploited or being positioned in such a way of you want to be leaders in AI, you want to be leaders in data for AI, we'll give you a data center, we'll give you the tech, we'll give you the talent, or we'll make teleprograms in your arena. And I see these as some kind of test bed in some cases for technologies that perhaps are lesser regulated in those arenas than they are in our own jurisdiction, where we have got a strong sense of rule of law.
Use this microphone if I'm talking. Have we got any questions in the room? Yes, we have 2, 3 hands up. So if we could, you put your hands up boldly and
down there.
Yeah.
Hello, thank you for that talk. I was hoping that you might comment more about the hype theory and my reflections on AI. So I have attempted to use ChatGPT to summarize cases, and I have found that it hallucinates and misunderstands cases so much that it's essentially unusable. And based on that, I wonder how much the fact that we're so concerned about AI taking jobs and taking over the economy, and again, recognizing that there are specific tasks that AI is very good at, but in general, does that say more about AI, or does that say more about some of the weaknesses of our society and economy? And to give a specific example of this, you talked about AI, ChatGPT, being able to pass legal exams. Does the fact that a system systematically hallucinates and misunderstand cases can pass legal exams say more about technology, or does it say more about the paucity of our examination techniques?
Shall I have a go at this? I mean, there's a lot in your question. Just to say, this is not a criticism of your question, it's just an observation that I don't know what my fellow panelists say. I'm not a fan of the term hallucination because it attributes human capabilities or lack of capabilities to machines. And so, I mean, hallucinations are misperception of some kind of sensory experience. That's absolutely not what's happening when these machines hallucinate. So let's talk about what we're really saying is these machines make mistakes. And they make mistakes for a whole bundle of reasons, and some make more mistakes than others. And if you're in my kind of business, and it's not, I can't promise you how the future is going to unfold. I've just spent my life trying to think about this. I say to you again, if you look specifically in legal research, when I look, and you should have a look at the research that's just been published this week, essentially a form of randomized control trials looking across 5 or 6 of the legal research tools. Some of them really are performing at far higher levels than others. And when you look at the might of organizations such as LexisNexis and Reed Elsevier, Thomson Reuters, and so forth, and Walter Kluwer, these organizations, the systems we see are the worst they're ever going to be from now on with these organizations. They're just going to get better and better. It may well be they'll never be problem-free in the same way as humans are never problem-free. But if I put my money on it, I'm saying by 2030, these systems will be pretty much good to go. That's my bet. I might be wrong. I might be a couple of years off. I think to hope or believe that they're just going to stay as they are just now, which is for many purposes not particularly useful, but alerting and perhaps a good parlor trick, I think that would be complacent, is my view. And when I say things like, what if AGI, I'm not saying there will be AGI, but we have to give some thought to this possibility. And I think we certainly have to give some thought to the possibility that within a handful of years, legal research will be transformed by these ever more capable systems. And if you look at the amount of capital these companies are attracting precisely to overcome these shortcomings, precisely to improve their performance, my bet's on the technology just now. And that may or may not, as we're trying to suggest, it may or may not say something about humanity, or may not say something how we test and evaluate humanity. I simply make the point, if you're looking at these systems as simple tools, they're going to get a lot better. How much better, I can't tell you.
But if I had to put money on it, I'd look at 2030 and say the research tools are going to be very different. Now, sorry, there's one other, very briefly, that there's a difference between AI systems for law being good for lawyers and AI systems being good for the general public. And so you give someone like Jacob, who's a very seasoned experience, you've seen tonight, great performance, a great barrister. He'll look at the output of a legal research tool and he'll smell a rat. He'll think, this doesn't feel quite right. He'll know where else to look and check. The average person doesn't have that facility. So the systems for general public use are going to have to be a level up where they have somehow reflect that extra level of skill the lawyer's got. I still think these systems will perform at that level. And it's not just in law. I'm monitoring carefully in medical diagnostics as well. Similar there. Amazing.
And this is why context matters, because in those legal contexts with the 4 different organisations you mentioned, they're going to be using small language models at the back end, probably with the front end of what I often do as an affinity loop is a retrieval augmented generation system. And so it's really keeping it very close to its kind of chest, all the cards that it's playing in terms of the content it makes available to you as a user. It knows that you are looking for law, you're looking for law of a particular type. And so those tools and the way it presents to you will be in a much more legal ease and language perspective than it would be if you were using a Joe Public GPT with a very large language model at the back, using the world's wealth and the world's worst of information. And yeah. And to remember what a large language model actually is, it's a prediction engine of the next word or sentence or how the paragraphs flow together. What it's essentially giving you is the outcome, you know, as we were talking about Black and Decker, is does this piece of linguistic output, whether it's audio, whether it's visual, or whether it's written, does it flow? Does it make human sense? Will it be readable by a human and understandable? And then it feels like it's done its job. That's the answer.
Yeah. Our next question, I think there was
Thank you very much. You've spoken about AI being a sort of 4th industrial revolution. I wonder if AI is a sense like call to the industrial revolution in that sense. So a powerhouse and essential to change, but damaging to the environment. So the UN Environmental Programme in September 2024 wrote, and I quote, "The proliferating data centers that house AI servers produce electronic waste. They are large consumers of water, which is becoming scarce in many places. They rely on critical minerals and rare elements, which are often mined unsustainably." I wonder if you could speak about sustainability and use of AI and the role of law in balancing, expanding AI and the protection of the environment.
I think that's probably a whole subject matter all of its own. And as far as I'm concerned, I'm not an AI expert in that sense, so I wouldn't really want to go delving into sustainability in AI. But we have, just for your information, you might be interested to know it. It's called MKAI. It started out as Milton Keynes AI, but I think it's moral and knowledge AI now. And there we have a number of people as sustainable farmers who are really into AI and sustainability and climate change. So do please go in there and delve around. And I think Edward Darling is one, he's in Cambridge. There's a number of experts who will have that debate with you and can help you on that. It just so happens that's not necessarily my little theme, but you know, in terms of my expert interest outside my legal world. But I'd be delighted to hand over to anybody who can help with that.
I'd like to make 2 observations. And you were one of the people whose hands went up who looked more experienced than others in AI. So you've obviously given the area some thought. It's a great question for a couple of reasons, but I think we're going, I don't tend to use the 4th revolution term myself. That's not entirely relevant, but, and I think there are some big distinctions between these changes and the Industrial Revolution, but I suspect we're going into this revolution with a far greater sensitivity to the impact of the new technology or environment. Insofar as I can see from my study of this, these issues were not really discussed and people had no sense of the fallout in environmental terms of the Industrial Revolution in the 18th and 19th centuries. Now, there may well be some fallout from this one that we just simply don't know about, which troubles me a little.
But I think we have people like you asking these questions, and we didn't have people asking these questions. The second thing I wanted to say was that there's another way of looking at the million-fold increase in the power and capability of these systems, that actually the same performance could be achieved for a millionth of the energy. So it's not all, it may not all be devoted to making these systems more powerful. It'll make them far more energy efficient. And that's another implication, I think, of the China breakthrough. If we really can find far more effective techniques for training huge bodies of data, perhaps we're not going to need the same, we're not going to see the same consumption of power and liquid. But these are, it's fascinating, isn't it, that these are issues of which everyone is aware, but nonetheless, you just see these big tech companies are talking about having small nuclear reactors next to their data farms. At any cost, they're driving ahead. It's the market doing its stuff, for better or for worse. But I say again, I think we are asking these questions that are insensitive to these issues in a way we simply weren't, I don't think, a couple of hundred years ago.
Good read is The Singularity is Near, a wonderful book.
Yes, well, there's two. There's a man called Ray Kurzweil who's written a couple of
That's
books.
right.
One's called The Singularity is Near, which I think was probably 2014. He had a second book, and he may be a very clever guy. I'll tell you a couple of things about him. See, this is being recorded, so I just have to. Anyway, his most recent book, 2024. I was going to say he's an amazing guy. I think he's one of my favorite futurists, but not maybe so imaginative in his titles for books, because his latest book is The Singularity is Nearer. But that's the book you should look at. He actually has written also a book that's subtitled "Live Long Enough to Live Forever." I think he takes, I believe he takes a couple of hundred vitamin pills a day. So he's not your regular Joe, but actually his work is phenomenal. And he's been an amazing inventor. But he, in his latest book, does deal with this issue, and it's worth reading.
Yes, it really does go into detail about sustainability as part of a very large number of topics he covers, and also all the matters about the level of energy use as we non-exponentially increase the use of our. So do have a read. It's very
Can I add two things?
yes,
So I think there's one aspect where we've got the increase in data centers or changes to data centers potentially, and because of energy and infrastructure problems, and then the other one is from a data sovereignty perspective. I'm coming back to the competition perspective, that we're seeing a number of nation states wanting to have their own data sovereignty, their own data spaces, and control essentially over data, and so they're not at the mercy of a big organization that's not in their jurisdiction. So I feel like there's a play in the law that can be had to help deal with some of the outcomes of the issues of having increasing numbers of data centers and data spaces that are causing climate issues. But then, so that's the kind of one point. The second point I wanted to make was there has been the use of the fundamental rights framework to have cases in Europe at the moment for climate action. I do encourage you to go and read them. I have pulled them up here because I can't remember off the top of my head. So come and see me afterwards and we can talk about that. And the third thing I did want to mention is, I think from the inside out, this is maybe something from a solicitor's perspective. I believe it was a Chancery project that was done with the Law Society maybe a couple of years ago, essentially helping lawyers to think about how can they structure deals and how can they structure contracts in such a way as to think about the obligations of each parties to for climate action and sustainability and the likes. And obviously you've got the WE regs and everything to do with the actual technologies themselves and devices and the safe disposal of them, but also holding people a bit more account for the transparency reporting. And we're seeing corporate transparency reporting happening in Europe more so obviously than the UK. But yeah, we are seeing a plethora of law coming out, but also I think there is power in our hands as transactors of the law to think about what is the law that we can help choose and use and shape to be better for climate action, including using fundamental rights framework, and also, you know, as contracts lawyers and the likes, or framing transactions between parties, how can we frame that so the obligations on parties are mindful and really do hold each other to account for the outputs to climate and the outcomes to climate that they produce?
Any further questions from the floor? Yes,
Put
Laura.
forward. Trish, you did touch on this earlier already, but given the rise in AI technology that uses people's faces in videos to falsely implicate them in crimes they never committed, what is the lawfulness of artificial face recognition in public spaces?
Before we go to Trish,
Bar
could
and
I,
bridges, as I
Jacob,
like
do
to
you have
say.
anything you would like to say about that, or would you like Trish?
Yes,
to deal with it?
I'm very happy to have a
Yes, thank
first,
you.
first go. There has been case law on this in the UK. The Bridges versus South Wales police case is an important precedent on this. This was a case where an individual challenged the use by the South Wales police of automated facial recognition technology, in particular using machine learning in public spaces. And the police's use of that technology was found to be, on the particular facts of that case, unlawful because, among other things, they had not adequately complied with the public sector equality duty, they had not adequately complied with their duties as a data controller under the GDPR to undertake impact assessments, and they had not adequately engaged with Article 8 of the ECHR on the right to private and family life. Now, it's important to say that is talking about the legality on the facts. So the police could have fulfilled those requirements and obligations, but they just didn't do so adequately. And among other things, they basically said, well, we're relying on the third-party provider of software, which has told us that it has trained this system in order not to discriminate against women or people of certain ethnicities, and they just stopped their inquiries there. And what the court said, among other things, is that the public sector equality duty is non-delegable. And this is very important for public authorities and anyone fulfilling a public function, because it means that you can't just procure something, and typically you will be procuring an AI system from a third party rather than developing it independently. You can't just procure something and take the developer's word for it. You need to independently investigate. So there's no absolute bar on this technology being used, at least under UK law. In the EU, I won't go into detail on this, but in the EU, there is now, with the EU AI Act, some quite complicated law around the prohibition of mass facial recognition in public places, subject to numerous exceptions. But even under UK law, there are various hoops which one needs to get through in order to do this lawfully. And there isn't a single source on this. There's data protection, which sets down various requirements on the lawfulness and the fairness of data processing. You need to show that you have a legitimate interest, that you've balanced competing interests in this regard, as well as the human rights implications if you're a public body. So all of these things need to be taken into account. They can be fulfilled, and through adequate compliance techniques, it is certainly possible to fulfill them. But it's difficult, and most organizations, I think, are unlikely to be complying with this at the moment. If you're using facial recognition or behavior recognition in your building, which many cameras are now integrated to be able to provide, there is quite a high chance, I think, that that is being done unlawfully as things stand. And so there's a major opportunity, I think, for lawyers to assist clients in complying in that regard and to advocate for those whose rights are harmed by non-compliance.
Yeah, and I would totally concur with that. And just to add, in terms of the impact assessment itself, that was a DPIA, a data protection impact assessment, that was expected to be considering the fundamental rights and freedoms of individuals that were impacted and affected by their AI deployment. I think the challenge is that was not an apples for apples comparison. They likely also in South Wales Police did not have the relevant expertise of human rights expertise to actually really think about what was the impact to Article 8 in rolling out and thinking about and assessing and evaluating the impact assessment itself. So that's where really the compliance rubber hits the road and why there might need to be standards. Just bringing this to an EU lens slightly, certainly what I'm seeing in the EU standards making, under the realms of the JTC 21 working committee of which I'm working, we're not expected to be considering the fundamental rights impact assessment that public sector bodies or those who are fulfilling public sector services and duties would be expected to do. And under Article 27 of the EU AI Act, that is in the deployer's gift, that they are expected to be the ones to do the fundamental rights impact assessment, very much akin to what would the police be doing under a DPIA when they've procured this in from a third-party provider. But what we're seeing and what I'm trying to present in the standards fora is how can we get providers of AI, just like that was a provider for South Wales Police. I don't actually know who provided that system actually, but I'm thinking about it. But what they needed to do and would have had to have done to think about the impact assessment for fundamental rights from the very designing and developing before and prior to deployment, because they have categorically, and there are many industries represented there, are categorically saying we're not responsible for FRIAs, we're not responsible for fundamental rights, we're not expected, even the standardization request from the European Commission is not expecting them to do a fundamental rights impact assessment. So we're phrasing this and working it so that there's an impact assessment considering due diligence for fundamental rights, identification of those who might be impacted and affected. What does that look like? What's the scope? How can we look at those in each of the individual rights, including Article 8 or potentially other articles that may well be relevant? And then where's the proportionality analysis? Where's the appropriateness of this going and being rolled out? And what could be the ultimate impact? And is it even remediable ultimately and compensatable? And that's the starting of the thinking that I was suggesting earlier on, but we're seeing it firsthand. And Aaron Bridges, I quote pretty much weekly in the standards fora and JTC 21.
So we've got case law, we've got this, we've got that. I mean, I've just, hammer to crack an egg. Why don't we get a global AI Act and have some sanctions involved? And maybe we might get there in order to be able to implement change before and anticipate dangers, if you like, and risks. But I'm just throwing that out. We have another question.
So one more online. I've lost where I got it now. Okay, assuming AI is able to litigate in its entirety by the late 2030s as a very human process, is the important question now not turning to should AI perform this role as opposed to could it?
Okay, well, we had a case just the other day that involved somebody, I think it was the Benelux countries, and BOIC there. It was about patents, and the applicant decided to put ChatGPT into the documentation when they arrived in the building as his representative. And ChatGPT lost the case for him. So there's hope for us all yet. Anybody want to answer that?
Yeah, yes. I mean, the short answer is, in fact, yes. The slightly longer answer is that this takes us into the field of what we call AI ethics. And one of my concerns about AI ethics of today is the debate about what machines ought to do and ought not to be permitted to do is very much focused on the current technologies. And so most of the stuff I see, particularly in business and amongst my clients, when they're talking about AI ethics, it's generative AI ethics. And generative AI, I should have stressed more, is simply the latest chapter in this ongoing story of AI. It's not the last chapter. And what it is we should be doing today, I think, is asking about the ethical implications of AGI. That's how, in my view, that's the ethical discussion we should be having. That's to say, the ethics, imagining a world in which these systems could match human performance. Under these conditions, where would we draw the moral lines? Where would our boundaries be mapped out? And it is precise. That question is a very good one, because I think we have to think about the moral implications of these unfathomably capable machines in the 30s now rather than when they're developed. Others think very differently. Others think, no, I'm afraid the AI world's littered with nevers, but they always say, oh, and the system will never do this, will never do that. And then it turns out it can do that, and we're scrabbling about trying to have coherent ethical discussions. So I think we've got to be thinking deep into the 30s, imagining highly capable systems and really stretching our own thinking about what we think right or wrong or good and bad in such a world, and how it is we learn to coexist with these increasingly
capable systems.
I'm just going to say, I wonder whether Jacob, in let's say 20 seconds, can answer the question. Do you think that this audience, and indeed every audience out there, any potential child at school looking to do law and want to be a barrister, would be saying, ooh, I wonder if I ought to make sure I concentrate more on my STEM subjects and or take certification in AI and or technology? What do you think? Do you think it would help? Seriously.
Well, I remember when I was thinking about whether to become a barrister, my father said to me, and this was back in the early 2000s, don't bother becoming a barrister because with the Legal Services Act, solicitors will be able to do it all in a few years' time. And the bar is a dying profession. It's very parochial, so you shouldn't pursue it. And here we are. Almost 20 years later, and there is still yet life in the bar. But what I would say is that one does need to constantly adapt. You need to adapt to survive. So the practices of barristers that were acceptable 5 years ago, that are acceptable today, are not going to be the practices of barristers that will be acceptable or profitable going forward. So one does always need to look at what additional skills you can have. And the beautiful thing about the bar, I think, is that it's a profession that you can make whatever you want to of it. You can combine it with other interests, you can combine it with other skills, and making your own career of it in an independent sense, not doing what everyone else is doing. That is the thing I would recommend.
Yes, thank you very much indeed. It's sort of life in the old dog yet, that is to say the bar. Going back to what I said at the beginning, curiosity, knowledge, vigilance, strategy, and flexibility. And if that hasn't actually got everybody talking about things that elided, that met, that matched tonight so well, all our three speakers, one with the other, like a jigsaw clicking together. It was magic to listen to. I hope you agree. It was insightful and prescient, and I hope it gives you sufficient information and excitement to spark your own research and to think even more deeply than clearly you already all are, both here and online, to promulgate your careers in whatever direction or directions, as Jacob has indicated, you may wish to take. I would like to thank Richard. The phenomenal trajectory of AI, generative AI, general AI is progressing. He spoke about that, the adaptation that we must implement as lawyers, but with an emphasis on it being client-centered, what the client wants. Trish, in helping us understanding how we can at any one time take the existing technology and law, soft or hard, to challenge the misuse of AI and to prevent what I love she called the breach of personhood. And Jacob, from case laws and the cases he's provided us on proving the negative, I think that's probably what those cases might have been a bit about. And taking the initiative on looking ahead and encouraging us to look under the bonnet. Again, I love that phrase, look under the bonnet, getting in there to understand the arena that you are in and are going to be in for the rest of your professional lives, whatever profession, wherever you are. It's here, it's coming, be aware. I'd like to thank enormously Gray's Inn and the phenomenal hard work and input of our Director of Education, Tony Charles, and our Gray's Inn Training Education Officer, Rachel Orr, who had so many versions of that reading and research document you've got as to not be true. There's more coming, one more, I promise. Last one, promise. Without their enthusiasm and energy, this tonight would never have been able to happen. And finally, to you all, present and remote, a huge thanks for your attention and participation. We here, all of us, wish you all success in your future careers, whatever and wherever they may be. And we hope sincerely that Gray's Inn, your inn, has helped you to form and nurture ideas and career paths for your successful futures.